In recent weeks, there's been considerable speculation circulating online and across YouTube about the possibility of Congress using the 14th Amendment or other constitutional provisions to prevent Donald Trump from taking the oath of office or being certified as the President of the United States. While these theories resonate with those who refuse to accept the election results, it's essential to address this head-on and clarify the constitutional realities. The theory stems from the 14th Amendment, particularly Section 3, which was enacted during the Reconstruction era following the Civil War. Its primary purpose was to prevent former Confederates, those who had rebelled against the Union, from returning to positions of power in the federal government. The language of Section 3 prohibits individuals who have engaged in insurrection or rebellion against the United States from holding federal or state office. However, Section 5 of the same amendment empowers Congress to enforce the provisions of Section 3 through legislation. The historical context of this amendment is crucial. After the Civil War, Congress sought to prevent traitors who had waged war against the Union from seamlessly reintegrating into political leadership. Jefferson Davis and other leaders of the Confederacy were barred from reclaiming their seats in government unless Congress explicitly removed their disability through legislative action. Analyzing the legal framework, it's evident that invoking Section 3 of the 14th Amendment to disqualify Trump, or any candidate, would require congressional action. Specifically, Congress would need to pass a law or establish a process to determine whether someone qualifies as an insurrectionist under this clause. Moreover, any such process would necessitate a two-thirds majority vote in both chambers of Congress, a nearly impossible threshold given the current political makeup. It's important to highlight the precedent set by the recent Supreme Court case, Trump versus Anderson, which further undermines these theories. This case addressed whether states could unilaterally bar candidates from federal office based on accusations of insurrection. The Supreme Court ruled unanimously that states lack the authority to disqualify candidates for federal office under the 14th Amendment. The ruling emphasized the need for federal processes and congressional authority in such matters, reinforcing the principle that only Congress, not individual states, can enforce the 14th Amendment's provisions. Critics who point to other constitutional amendments, such as the 12th and 20th Amendments, also misinterpret their scope and application. The 12th Amendment governs the Electoral College process and the counting of votes, while the 20th Amendment addresses the timing of presidential inaugurations. Neither amendment provides a mechanism to bypass the congressional process outlined in the 14th Amendment. To put this in perspective, even if Democrats controlled Congress, which they currently do not, the procedural hurdles are insurmountable. For example, removing a president through impeachment requires a two-thirds vote in the Senate. Applying the 14th Amendment's disqualification clause similarly demands congressional approval by supermajority, making it unrealistic to expect such action against Trump given Republican control. Legal experts analyzing Trump versus Anderson have emphasized that the Supreme Court's opinion, while narrowly focused on state authority, includes dicta that clarify the broader application of the 14th Amendment. The court indicated that any attempt to disqualify a candidate must follow congressional procedures, rendering state-level actions ineffective. This interpretation aligns with long-standing principles of federal supremacy and separation of powers. It's understandable why these theories resonate with those disheartened by recent election results. Many Democrats are grappling with the reality of defeat and searching for legal avenues to counter Trump's resurgence. However, wishful thinking cannot substitute for constitutional law. Misreading or cherry-picking constitutional provisions only fuels misinformation and distracts from more viable political strategies. As someone with over 30 years of legal experience, including extensive work in constitutional law, I bring a level of reliability and gravitas to this analysis. Unlike YouTube commentators or social media influencers pushing misleading narratives, my perspective is grounded in legal precedent and rigorous study. Constitutional interpretation is complex. It requires years of education and practice, not quick takes or viral videos. Critically, Trump versus Anderson should not be dismissed as narrowly focused. While its immediate issue was whether states can bar candidates, the decision carries broader implications for interpreting the 14th Amendment. The court's reasoning suggests that enforcing Section 3 against a presidential candidate would necessitate congressional action, further supported by Section 5's enabling clause. The logistical challenges are equally significant. Even assuming Democrats regain control of Congress, securing the two-thirds votes required to enforce the 14th Amendment is an enormous hurdle. The Senate, for example, would need 67 votes, a virtually impossible target given the current partisan divide. Moreover, any argument based on election fraud to invalidate results would face overwhelming legal and factual obstacles. Multiple investigations, audits, and judicial reviews have found no evidence of widespread fraud sufficient to alter outcomes. The Department of Justice, the Cybersecurity and Infrastructure Security Agency, and bipartisan election officials have all affirmed the integrity of the election process. Efforts to frame Trump's re-election as illegitimate not only lack legal grounding but also risk undermining public confidence in democratic institutions. Democrats must focus on rebuilding trust, addressing voter turnout issues, and strengthening their platform to win future elections, rather than clinging to far-fetched legal theories. Reflecting on the broader implications, the Democratic Party faces a branding challenge. Millions of potential voters abstained in the last election, and engaging these individuals should be a top priority. Strategies for mobilization and outreach must focus on presenting a compelling vision for the future, rather than dwelling on legal battles unlikely to succeed. Addressing the role of media and commentary, it's tempting to chase sensationalist narratives for views and engagement. However, responsible journalism and legal analysis demand adherence to facts and established precedent. My approach prioritizes credibility and informed discussion over clickbait tactics. While the prospect of preventing Trump from assuming office through constitutional loopholes may seem appealing, it's ultimately unrealistic. Democrats must confront the political realities and work within the existing system to achieve meaningful change. This includes focusing on legislative initiatives, voter mobilization, and preparing for future elections. In conclusion, the 14th Amendment's provisions were designed for a specific historical context and require congressional enforcement. The Supreme Court's recent rulings reaffirm this framework, highlighting the need for due process and legislative action. Misinterpreting these clauses to fit political agendas only distracts from the critical work needed to strengthen democracy and advance progressive values.